did they arrive at this in good faith? Because a lot of people believe that, I mean, why now of all the times?
No, in good faith. It would have been in good faith in the sense that for about 2 years now, we have been expecting that the governor will recover. And we cannot wait ad infinitum. That is why he said it is time we do what the Constitution requires us to do. Because otherwise, we will continue to wait, and there is no limit to how long you can wait.
What are we waiting for? We're waiting for the governor to get
recover,
better.
Because they said that he could get better and get back to office. Mm-hmm. And that's the argument of those who are for, the governor.
What they are envisaging now is that if it is established that, you know, he's not going to get any better than they're saying
he's not fit enough as it stands now, you know, to run the affairs of the...
He should be let off government.
Oh, sure, that's what the Constitution says.
Okay, well, yes, Mr. George Ekeh is still here with us to shed some light on this one. The argument at that time, while Mr. Falana was here, that they were wrongly charged under 52.1 and it should have been 52.2. Do you agree with that?
With respect to the learned senior advocate, I disagree with him. I allow him his opinion, but they were rightly charged. They were rightly charged under 50. Armed Forces Act, LFN 2004, Section 52.1. But I think his opinion is that they should have been charged under 52.2. If you read 52.1, you will find out that the ingredients of the offense include violence. Indeed, if you want me to read it out, I can, but you see the major issue there is two of them are under mutiny, but one is with violence. The other one is probably envisaging a situation where...
Maybe we should read it for those who don't.
Okay.
Let me see if I have the same one here. Mm-hmm. Who says, takes part in a mutiny. Mm-hmm. No, a person subject to service law under this act who, A, takes part in a mutiny involving the use of violence or the threat of the use of violence, or having as its object or one of its objects the refusal or avoidance of any duty or service against or in connection with operations against the enemy or the impeding of the performance, impeding of the performance of the duty or service. Or then it goes to 2.
Yes.
Which then says...
No, it goes to B.
Okay, B, incite any other person subject to service law under this act to take part in a mutiny, whether actual or intended. Mm-hmm.
Is guilty of an offense under this subsection and liable on conviction by a court-martial to suffer death.
Then 2, which you talked about.
Good. He said, bearing this, in other words, without involving the use of violence, threat, or the use of violence, if you incite any other person, any other subject to service, any other person subject to service law under this act to take part in a mutiny, whether actual or intended. That's the one that carries life imprisonment.
So what do you disagree with section 52.1?
The 52.1 is the most appropriate place because, you see, these are soldiers who were shooting at their GOC, as it were. They were not just protesting. So there are 2 categories of mutiny. Mutiny may well be like the one that we had, I think it's in Ibadan or wherever, where the soldiers were protesting against the authorities not paying them their salaries or their allowances or whatever that was due to them from Liberia, as it were.
Was that violent?
No, that comes under section 52.2.
Okay, so that was rightly...
Yes, yeah, sure.
But they were also charged for mutiny at the time.
Yes, all of them are under mutiny.
Okay.
Mutiny is when you disagree with constituted authority while you are subject to this service law, as it were. So, but this one is a situation where they were shooting, as I'm talking about, when the violence envisaged in this law is probably the use of guns, because that's what is available to the soldiers. It's probably not placards, it's not penknife, it's not broken bottles. It's the use of guns. And one thing we must note is that mutiny is about the most severe offense in the army. As you are being recruited, they are shaving your hair that you are a recruit, throwing the uniform at you, this law is made known to you. You are aware of it.
Does the manner of your disagreement matter as long as you disagree? Is that the case? Because if you're right,
the law says now, if you do that through violence, which suggests that there may be other means of disagreeing that is not captured in
not
this
that
thing.
you cannot disagree.
No, not that you cannot disagree, but that there may be other means of disagreement. But this law is bothered about when you begin to get into mutiny via violence. So the punishment is death. It doesn't even have an alternative. And this is very clear to the soldiers. Again, let's talk about the panel, because somebody mentioned that the members of the panel are not lawyers, that it may be good to get judges, into the panel and all of that. Those people are lawyers. A number of them are lawyers. We just came back from an MBA conference in Owerri. I can tell you about 5% of the people who attended that conference came in uniform, naval uniform, Air Force, Army uniform, and all of them. These are all lawyers. And the lawyer is properly trained in law. The fact that he's not wearing wig and gown, law does not reside in wig and gown. It resides in the head of the wearer. So if he's wearing khaki and he is able to interpret the Evidence Act and probably operate it, then he is. What does it take to be a judge? A judge is a lawyer. It's just that he moved from the bar to the bench. So those people are very competent to handle the matter. So in other words, let us as lawyers also make a distinction between being Amnesty International and upholding the rule of law. Because in an attempt to do human rights advocacy, we find ourselves being Amnesty International, almost like the rule of law is now being subordinated, as it were.
True.
Here is a situation where it is a right court, because a court martial is a proper court. Any judgment that is coming from a court martial is as valid as a judgment that is coming from a regular court. So it is constitutional. And the only thing that you can now bother about is that their rights, their constitutional rights, have they been breached? The two rights here that are major, I have said it here on this program, that there is no right in the Constitution that cannot be derogated. The highest right you have in the Constitution is your right to life. If for any reason you commit an offense that the sentence is death and you are convicted for it, your right to life ceases to exist.